I'm Martin Zummach from the Northern District of Mississippi Bar, here representing Mr. Adrian Hoyle. I'm sure the court has read the briefing in this case and probably sees the same difficulties that Judge Mills saw when this landed on his desk. Judge Biggers, almost 2 years ago, issued a memorandum of opinion wherein he very specifically dismisses the entire case of Adrian Hoyle pending against both Lynn Brown and Hunter Solomon in the city of Hernando, based upon the Heck Doctrine.
Okay, I'm going to stop you there. You dismissed it with prejudice based on Hecht, as well as a failure to state a constitutional violation.
There is parenthetical, the language is what the language is. The parenthetical language regarding notwithstanding the fact that there's not an excessive force claim, it's barred by Heck.
Right, but
it's what the judge said.
He makes the alternative finding, and I didn't see you appeal that, and the only way he could dismiss with prejudice would be based on that alternative finding, correct?
Judge, when the memorandum of opinion came down dismissing the case, I believe, based upon the Heck Doctrine, by the plain language of the ruling, I think I did the right thing on behalf of the plaintiff and said, look, I think there's been a manifest error of the application of Heck, and called the court's attention to Ballard so that this entire case could be dealt with at the district court level.
But let's say you'd been able to go and wipe out his conviction. The dismissal with prejudice wouldn't have been appropriate.
Your Honor, I have to be candid with the court. I didn't look at it from the standpoint of had I gone and set aside Hoyle's conviction, because frankly, Hoyle has never denied that he in fact ran from the police.
Well, he does deny that when he says, he's trying to say as a 1983 plaintiff that the police pursued him without justification or cause.
That was an alternative allegation in the complaint, yes, Your Honor.
That one can't escape Heck, can it?
I agree with you. That one paragraph regarding
okay, but now that this is just me asking. And,
I know, and I don't want to step on your question.
Once you put in an allegation in your complaint that you're admitting now is Heck barred, do we get to sort of cross that out as surplusage, and the rest, let's assume, for the sake of argument that I agree those might not be? What's your authority that we can do that?
Your Honor, the allegations of the plaintiff have to be taken as true, and the allegation is very clear in the complaint that Mr. Hoyle surrendered, and after surrendering, he was attacked by the dog, and after he was handcuffed, Hunter Solomon punched, kicked, and stomped him, which are clear matters of excessive force. That's why Judge Mills had such difficulty with it. Now, his guilty plea was for fleeing.
So the guilty plea knocks out the portion of his 1983 allegation, the paragraph that says they didn't have cause, correct?
They didn't have cause for what then, Your Honor?
Pursue him.
I agree with that.
Okay, and then you have a lot of allegations that suggest that even sending the dogs on him or forcibly subduing him were excessive force. And yet, when he obtained the guilty plea in the rearraignment, you aren't disputing that he said the police thought he had a gun and they thought he would resist. So those are problematic, whether they're Heck barred or just inconsistent with sworn statements he made. Those allegations have a problem too. Do you agree or not?
I disagree, because there's a line of cases from this very panel that says that a criminal suspect can be guilty of assault on a police officer, and yet the police officer be guilty of excessive force upon that suspect.
Right, but why? Can you undo the statements that your client made at the rearrangement? That's my question.
I'm not going to try to go behind the statement made by Hoyle in order to get himself out of state jail. I'm not doing that, Your Honor.
You're not attacking those statements.
I'm not, Your Honor.
Doesn't that mean we now cut your complaint even more? All that's left now are the allegations that are after he was cuffed and couldn't resist anymore. What Solomon did at that point. That's all that's left.
Not just Solomon, but Brown as well.
What? Solomon and what?
Not just Solomon, but Lynn Brown as well. There's an allegation that the dog got Hoyle
before he's cuffed. The dog attaches before he's cuffed.
That's right.
I think the video shows that within 30 seconds or something, the dog is detached.
Whether or not that's reasonable or not would be a question of fact, and that's why...
But am I right that all that's left of your complaint is the portion of time and the behavior of the police after he was cuffed? Do you agree or not?
I disagree slightly. I would say that the examination for the court, the district court level, would be from the time Hoyle surrenders, gives both hands. You look at Poole. Poole says exactly that. When he gets out of the pickup truck and he gets shot, his hands were visible. He didn't even have his hands up. I would say, I would move it back a little bit and say when Hoyle gets out with his hands up, surrendering, everything after that has to be analyzed. I'm not saying it's ipso facto excessive. In other words, could he recall the dog quick enough? Or, I'm not saying that it's all naturally excessive. I'm saying that the point in time is when Hoyle gets out of his car with his hands up. The conduct of the officers after that should be examined. And, Your Honor, I think you have to look at Judge Bigger's memorandum opinion. He does not talk about qualified immunity. He does not talk about Monell liability. And he says nothing about Hunter Solomon's conduct. So it's clear that what he's doing is precluding this case based on Heck. And all of the cases out of this panel have been very clear that once the crime or once the resistance ceases, then the examination of the force used comes into play. We've had it with inmates fighting with jailers, and the jailers then take them out into the showers and beat on him. And they say, Heck doesn't bar that. The woman at the car wash that gets her head slammed into the back of the car, and she pled guilty to assault on a police officer. This panel has said that's not a Heck bar. Poole is I think Poole's probably the most closely related, and that is the guy's driving through town crazy or whatever, and they knew this guy didn't want to go back to prison. He was going to be dangerous. He got out of his truck, and he goes to put his hands into the bed of the truck to get something so his hands are visible, and he is shot. This panel was real clear. That's his behavior was not a bar. His guilty plea was not a Heck bar.
Part of the difficulty, I think I'm not mistaken, you didn't file a reply brief, I don't think, in this case. So this argument, I'm not saying it's a collapsed argument, but
Hope not.
Well, in your principal brief, I don't remember you acknowledging that considerable portions were Heck barred or judicially stopped. That all you're focused on is the allegations of excessive force from the time he was, let's say, fully restrained. That's all that's left. That's your argument today.
Your Honor, I am conceding that today.
Yeah.
Addressing your question about why I didn't do that in a reply brief, because frankly, the memorandum of opinion of Judge Biggers was so shocking in light of this panel's analysis of Heck. I mean, it foreclosed the entire lawsuit. Remember, a motion in the pleadings, you'll see that a motion for qualified immunity was filed, which stayed all discovery. Nothing was done on this case until the motion to dismiss on the pleadings was filed by the defense, and then we get this Heck preclusion order. And then it sat for nearly a year and gets transferred to Judge Mills, and you don't have to read between the line of Judge Mills's order on the Rule 59 motion to reconsider or modify.
But do you have authority that a 1983 claim, if 2/3 of it is Heck barred, the remaining third still can go forward? You see my point? What's your authority for that?
There is no case law in the Fifth Circuit that...
There is no case law, but you would need that case.
What I was going to say is that the case law out of the Fifth Circuit, when they analyze the conduct of the defendant suspect, they do make a line of demarcation of when the offense, if you will, or the bad behavior of the suspect stops, or when he surrenders. They do make a line of demarcation, and they say all the conduct after that is to be examined for excessive force.
Okay.
Heck has been all but done away with across the country as it relates to excessive force cases. For the common sense reason is Hoyle pled guilty of running from the police. He didn't plead guilty to assault on a police officer or any of these kind of things.
Well, he has been charged with assault, right?
Sir?
He was charged.
He was charged, but those charges were dismissed. They were remanded.
Okay, you'll have to inform me because you practice in Mississippi. A remand to file means dismissal?
It's a dismissal, technically it's a dismissal without prejudice because in Mississippi they call it removing it to the inactive filing. And I've been practicing law for 30 years and no one knows what that means. But it's been dismissed, Your Honor.
So there was an assault charge brought. It is pending, but it's remanded to the file, or?
No, it's not pending at all, Your Honor. He was charged, he was put in jail, he couldn't make bond, and after he spent, I think, 17, however many months in the county lockup, his lawyer at the time said, look, plead guilty, they'll let you out today. Those facts giving basis, giving a foundation to the charges, I haven't seen that in 30 years either, especially the line in there about how Hoyle subjectively knew that Lynn Brown subjectively feared for a weapon. I've never seen that type of colloquy before, but I can't change those facts.
Yeah.
But the case law of the Fifth Circuit's pretty clear. Once he has his hands up, that's when the court and the jury has to analyze whether or not the police officer's response to that was excessive or not under Graham v. Connor, whether or not qualified immunity applies, whether or not, and you go down that path and you have a full, robust bit of litigation. In this case, even the case against Solomon was dismissed without one mention of Solomon's conduct in this arrest right there on the video. Not one mention is made by Judge Biggers of the expert affidavit filed in this case as it relates to the conduct of both Lynn Brown and Solomon. Not one mention is made in that memorandum of opinion. So it's clear that Judge Biggers' thrust was a heck bar. If he made a throwaway statement saying, hey, look, this is without evidentiary support, that's not what he always goes back to in his ruling. And that is, this case is precluded by heck. We could have cleaned all this up when I filed my motion under Rule 59 the next day and briefed it. This could have been cleared up at the district court level, but it wasn't. And I think Judge Mills has all been inviting this court, this panel, to send it back to the Northern District of Mississippi for a full determination. I mean, we've just done away with the civil rights case where a police officer is on video stomping a handcuffed suspect. We've just done away from that with that case. And yes, and he's put it to a heck preclusion. There's no other way around it. There's no way to dismiss the Solomon case, for example, without saying it was heck precluded. And his guilty plea for felony fleeing doesn't have anything to do with Hunter Solomon. Subject to your Honor's questions, I'm kind of in an untenable. This was procedurally, it was very difficult for me. I'm like, I've had cases dismissed before because, I wasn't able to show a Graham violation of excessive force or poor training or anything else. But get this opinion doing away with the case on the heck doctrine, procedurally, that's why we find ourselves here. And all I'm asking this panel to do is to vacate the rulings based solely on heck and send it back to the district court for Judge Mills or whoever it's assigned to deal with. And we haven't taken any discovery in this case. That's why that video, and that's why Jared Zawicki's expert affidavit, I think, should have been important to the district court to consider. And it wasn't. Thank you.
Thank you. You saved time for rebuttal. Mr. Butler? And you're here on behalf of all the defendants?
I am, Your Honor. Good afternoon. May it please the court. Todd Butler on behalf of Officer Brown and the city of Hernando. I'm joined at council table by Bethany Tarpley, who represents Officer Solomon, but I'll present the argument on behalf of our side of the podium, Your Honor.
When you say our side, you mean including Officer Solomon?
Including Officer Solomon, Your Honor. There are a variety of problems with the principal appeal, but the most straightforward ground for dismissal is waiver. In the district court, Judge Biggers made two findings. First, he said that the case was heck barred, and second, he said that notwithstanding heck, there was no excessive force claim on the merits. On appeal, the plaintiff challenges only the heck determination, and he does so only in the context of a Rule 59E denial. In fact, In the blue brief, he says, quote, that heck is the sole issue on appeal. It is settled in this circuit and elsewhere that appellate strategy does not work. When a district court decides a case on multiple independent grounds, the appellate has an obligation to challenge all grounds, and in fact, this court could affirm on any ground supported.
Okay, that may be my question. Is it a sequencing problem? When a heck bar is found by a district court, do we have to assess that first? Or can we affirm on either ground?
I think you can affirm on any grounds. I certainly take the court's point about the with prejudice versus without prejudice dismissal, but I think the broader point in this case...
Because usually a heck bar problem means without prejudice.
Correct. Correct. But I think the problem in this case is that there's a backstop rationale from the district court, and the plaintiff didn't challenge the backstop. Therefore, any discussion
When you say challenge the backstop, didn't give the district court any clearly established law that this level of force effectuated during an arrest?
Well, certainly he didn't in the district. He didn't meet the qualified immunity standard of the district court. But
Yeah.
the broader point is
That would be getting to qualified immunity first, wouldn't it?
well. My point, Your Honor, is that alternative argument was briefed in the district court below.
Yes.
But on appeal, that's been
It
forfeited.
was just waived.
So the heck determination is just academic in nature because there's a backstop rationale by the district court that was not appealed. Now, what I expected to happen in this case is that once we filed the red brief, that the plaintiff would come back in a reply and do everything that he should have done to begin with. Now, had he done that, I'd still be up here saying you don't get to do that either. You waive it if you wait to a reply, but we don't get there because there was no reply filed, there was no response to the cross appeal. So there are certainly interesting issues in this case related to the interplay between the criminal proceedings and the Section 1983 case.
If we had to get to heck, you heard the line of questioning.
Right.
I think it is clearly established here that if a suspect is handcuffed and not resisting, it is clearly established law that further beating or kicking would violate the Fourth Amendment. You're not disputing that as clearly established law?
I'm certainly not disputing the fact that the best claim in the case would have been against Solomon, but a few points I'd like to make on heck. First of all, as Your Honor noted, this is not a single charge that was brought. There was 4 different charges in this case, and because of the plea agreement, 3 of them were remanded. Under cases like De Leon, deferred adjudications trigger things like heck. The other problem is it's really a pleading problem here because certainly this court's cases say that you can have a claim that in theory would be reconcilable with the criminal judgment, but you can plead yourself out of court if you plead it in a manner that factually misrepresents the criminal judgment. So, and my friend on the other side said several times, he tried to draw this distinction about being in handcuffs and all that. Well, I mean, there's a recent decision out of the 11th Circuit that Judge Newsom wrote where I think he draws a distinction and calls it the difference between I didn't do it claim and I did it, but they kept beating me up after, I was in handcuffs. That's not what we had here. We had blatant misrepresentations in the complaint that called into question the validity of the underlying criminal conviction. He said in the civil complaint, I was pursued without justification when he admitted in the criminal case that he stole a car.
And he's abandoning most of that now.
What he is, Your Honor, but he didn't brief the argument that he got up here today and asked this court to save, and he has to do that. That's required.
The case he did brief, though, he cited Ballard, and that was the one that seemed to concern the successor district judge. I didn't see reference or discussion of Ballard in your brief. You're familiar with Ballard?
I am, Your Honor, and in my view, the heck problem and the heck fight in the district court was always over. The plaintiff presented heck as if it categorically never applied to excessive force claims. That's not the law. The law in the Fifth Circuit is that sometimes it does, sometimes it doesn't. It depends on how you plead the claim. And he didn't plead these distinct, discrete events. If you read the
Let me read the amended complaint. ROA 68, quote, Officer Solomon, after kicking Hoyle while in custody and cuffed, proceeded to stand on Hoyle's back as if wiping his feet on Hoyle's body, as if Hoyle's torso was a floor mat.
Yeah.
That's a pretty exact pleading post-cuff, post-resistance.
Your Honor, I'm not suggesting that there's not, those kind of allegations. What I'm saying.
What do we do with those?
You affirm on the ground of waiver, because we don't get to this alternative issue on the merits. Perhaps he had a decent merits argument. If he had addressed qualified immunity and attacked that against Solomon in his briefing, then I suspect Ms. Tarpley would not have ceded her time to me here today. But the bottom line is, again, there are interesting issues about the interplay between those criminal proceedings, but I don't think this court gets there. And,
Because that type of allegation wouldn't be Hecht barred, even with an expansive sense of Hecht, extending to rearraignment statements, or even to the remanded charges assault, because that specific allegation really is distinct chronologically.
I think if you plead it as I did it, but they kept beating me up claim, then I think that is the way you plead around Heck. That's not the pleading that we got in this case. The pleading we got in this case painted the plaintiff as a choir boy and said that he was attacked, quote, without justification, and that there was no reason at all to let the canine loose on him, when that's not what he said in the criminal case. He said that they let the dog loose because they feared he had a weapon. He admitted to stealing the car, and frankly, the sentence that he got, the trial court in the state court proceedings commented on the record what a deal he got and called it, quote, some fancy plea bargaining on behalf of his attorney, that's the type of sentence that he was able to get awarded. So to some degree, it was shocking that he would come back and file a Section 1983 case and certainly misrepresent and omit the record as he did in the complaint here. In the district court, we really engaged the plaintiff on Heck when he started talking about Heck in terms of it categorically applies to, or gets rid of excessive force claims, because that's just not the law. But really, judicial estoppel, that's probably what the better argument is here. Heck's obviously.
Well, you are reading my mind a little bit in terms when you're saying judicial estoppel is what we would apply as to his attempt to contradict statements he made.
Correct.
Whereas Hecht is reserved to contradiction of the elements of the conviction.
Correct. Yes. But I do think this Heck's obviously an interesting issue in this court right now, and this court has taken a broader interpretation to Heck than some other courts have, and that's one of the things. There are other cases that really get in the weeds and, will try to, carve out certain allegations and say, well, the plaintiff alleged 3 things and 1, 2 are Heck barred and 3 gets to go forward. That's not how this court has always talked about Heck. Heck really talks about it as we're going to compare the allegations in the complaint with the underlying factual basis in the criminal case, and if it calls into question and you're not being honest, then it can trigger Heck. And that sounds a lot like judicial estoppel, and there's certainly some overlay between the two. But again, all of this discussion is academic because we don't get to these alternative arguments because the plaintiff didn't press them. What we think the court should do is, apply the waiver principles and then skip straight to the cross appeal. On the cross appeal, our argument is that my clients were entitled to prevailing party attorney's fees under 1988. Now, of course, the statute by its text only talks about prevailing parties, but the Supreme Court has placed a higher bar on defendants than plaintiffs and required proof of frivolity or unreasonableness or groundlessness. But our position is that standard was met in this case. We think Judge Mills abused his discretion mainly for 2 reasons, just by focusing on the wrong things. He only talked about Heck in the context of my clients without talking about the underlying constitutional violation, without talking about the added layer of QI, without talking about Monell. And those are just different layers that make the case against my client's even weaker. And then when it comes to him talking about the merits, he only focused on Officer Solomon, and Officer Solomon didn't request fees. So his conduct was completely irrelevant to, whether or not my clients, especially the city, on the Monell claim, were entitled to fees because the lawsuit was groundless from the start. I'm certainly not up here suggesting that, anytime a plaintiff can't prove an underlying constitutional violation in a 1983 case that the defendant gets fees. That's not what I'm advocating for. But this case is a little bit different. It's certainly different in the way it was pled, certainly different in the way it was litigated. So I think really the best case on point for my fee request is Lofton versus Town of Prentice. And in that case, you had the district judge that rejected the heck argument, alternatively found no constitutional violation, and then awarded the defendants their prevailing defendant attorney's fees. So I would argue in this case it's even stronger.
Oh, so you're presumptively unavailable but frivolous because of waiver is more what you're saying in light of how difficult the chronology temporal distinction is. Is that
Well, in the district court, my point is that the heck bar is what it is. The estoppel arguments are what they are. But the case was so groundless that Judge Biggers didn't even find a need to get to the added layers of QI or Monell, which the plaintiff would have had to jump over those hurdles too in order to successfully.
But he did say the application of the heck bar was arguable. He concluded it applied. But he did say, did he not, that he thought it was kind of a closer question than you describe it as?
And we're talking about Judge Mills'
Sorry.
opinion. I think that's right, Your Honor. And I certainly am, again, I think the heck argument is defensible. I'm up here saying the stronger avenue probably would have been judicial estoppel, but I think under this court's cases, there are certainly questions about whether the civil complaint called into question the admissions and totality of this criminal judgment where you had 4 charges and you had a plaintiff that got on the record and said my plea is knowingly, intentional, and voluntarily, and then got in a civil lawsuit and omitted the fact that he ran from the cops for 8 minutes and stole a car and said that a dog came after him for no reason whatsoever.
Remind me, when you argued to Judge Biggers and he entered the heck bar, were you saying the heck bar applies because of the charges that were remanded to file? Probably not.
Yes, the cases that we never made the distinction between without prejudice and with prejudice.
Right, but did you say the heck bar was based on the remanded assault charges? Did you draw attention to that? He doesn't.
We drew attention to the whole criminal judgment, all 4 charges, all of the factual basis that underlined that.
And the colloquy at rearrangement?
Exactly, Your Honor. Exactly, yes. All of that was in the record. It was block quoted in the brief, and with comparisons of the civil allegations, juxtaposed to the criminal admissions. And so, we really do think this is a case where it qualifies for fees. Now, had Judge Mills said, talked about the right parties and got to the added layers and said, even notwithstanding all this, I don't think these defendants are entitled to fees. It's certainly an abuse of discretion standard of review. I probably would have found no basis to file a cross appeal on that. But the abuse of discretion, in my view, comes to the court because I think he just did the wrong analysis and he focused on the wrong things. And I think when you have an underlying procedural problem like heck, and then you put on top of that constitutional violation, and on top of that you got QI, and on top of that you have Monell. There's certainly a lot of hurdles you have to overcome in these cases, and he didn't really get off the ground at all. And when you add that on top of the way this case was pled and the way this case was litigated, then I think this seems to me a picture-perfect case for 1988 fees from the defendant. A couple things that I will mention to the court. Record at 571, that's the briefing of the plaintiff on the 59E motion. he acknowledges in the briefing that Judge Biggers performed a reasonable analysis for purposes of Fourth Amendment. He says there's no evidentiary support for the excessive force claim, and then he goes on to cite Fourth Amendment cases. There also can be no doubt that Judge Biggers considered and knew that there was a claim, against Solomon in the case. Record at 560 says there's an excessive force claim against both the officers in their individual capacity. Record at 563, he says the claim against both officers in their individual capacity are dismissed. Your Honor, unless you have further questions, I think that's my argument.
Thank you.
Thanks, Your Honor.
Appreciate it. Rebuttal argument?
All one has to do is look at Judge Biggers' ruling, and Mr. Butler just referred to it. At page 5 and 6 of Judge Biggers' memorandum of opinion, he goes into great detail about what the case law is on canine apprehensions cases, almost as if we're analyzing that, but without any reference to the disputed issue of material fact created by the expert's affidavit saying that the behavior was inappropriate. But Judge Biggers does give a passing glance to canine apprehension cases, but then very clearly states, as noted, however, the plaintiff's federal claim here is barred by Heck and is therefore ill-fated from the outset. That's the opinion I got from the district court, and that was the opinion that I wanted modified, clarified in light of Ballard, and I've counted 6 cases since Ballard came out that this panel has done exactly what I'm asking it to do today. And then it sat. So what we had before us is some passing mention of canine cases, and then, but that's too bad anyway, because Heck is a bar to you. And there's not one mention of any of the behavior of Solomon. Keeping in mind, we've had no discovery in this case because there was a QI motion filed. So we never get to Monell, QI, or anything else. It was just based upon the pleadings. And we get an order from the district court saying you're Heck barred. So my motion was to clarify or correct that problem. None of the parties have been able to litigate this case to get to the issues of qualified immunity or Monell or anything else, because this opinion came out and said your case is barred, and that's what it says. You can't deny it, as the plaintiff explicitly abandoned any federal claim except the claim of excessive use of force, and the court having found the claim to be Heck barred and without evidentiary support, the court will dismiss plaintiff's federal claim against all defendants with prejudice. I don't know what else to say other than this is not a Heck preclusion case. But yet this is the memorandum of opinion that I received from Judge Biggers, and I tried to correct that so that we can get into all these issues of what he said I'm talking about Hoyle, what he said and what he admitted to. I think I've been more than candid with this panel about Hoyle is not, regardless of artful crafting of a complaint or anything else, Hoyle did run from the police. That's what he was being pulled over for. I've been very candid with this court that the police officers chasing him it is not a violation of his Fourth Amendment rights. And I've been very candid when Hoyle finally crashes his car out let's face it, like an idiot. He finally had some sense of intelligence come across him where he gets out of the car with his hands above his head. This lawsuit is about what happened after he gets out of the car with his hands above his head. And a jury should be able, or the district court should look at it first, but a jury should be able to analyze whether or not the behavior of Lynn Brown and that dog remaining on that bite for 30 seconds or 3 minutes was appropriate under Schumpert, many cases regarding how long the dog should stay on bite. There's plenty of cases that a dog should not stay on bite while you're getting the handcuffs on. Once they've surrendered, take the dog off and handcuff them. But we don't even get to those points because Judge Biggers issues a memorandum of opinion dismissing it on the heck doctrine. So yes, I did try to, I guess, simplify or clarify or concentrate what my argument is, and that is, this is not a heck preclusion case. I'm asking this panel to vacate the order of Judge Biggers, send it back to the district court, and let the district court, Judge Mills, presumably, deal with all of these other issues. Thank you for hearing.
Thank you, counsel. Case is submitted. That concludes the case.